Hello, everybody, and welcome to the Gibson Dunn and Crutcher webinar on the Christmas Eve Trade and Cooperation Agreement that was made between the European Union and the United Kingdom. It was an agreement very much much awaited by both the European Union and the United Kingdom. As the years went by, literally years, about how long it would take to negotiate, it was said it was going to be done in July, then it's going to be done in October, then it was going to be done in November, and eventually it was done on Christmas Eve. If you were a parliamentarian like myself, it meant you were in a constant anxiety about what was going to happen to your Christmas holidays. However, the effect of the pandemic was that your Christmas holidays were curtailed anyway, and so we ended up in a situation where it was agreed on Christmas Eve. It was 1,250 pages. Then between Christmas and New Year, it was approved by Parliament on a final basis. It's nothing provisional about the approval that Parliament has given. And at the same time, an 85-page statute was passed in the course of an afternoon through both houses of Parliament. And that statute and that agreement will now determine legal relations between the European Union and the United Kingdom, maybe for generations to come. What we are going to try to do in this webinar is try and explain what the effect is, not going into the deep detail, but telling you broadly what the effect of that Christmas Eve deal is, because it's going to affect so much of commercial activity. We've got four speakers. First of all, Matt Aleksic, who's going to tell us about the structure of the deal. Then Attila, Borsos, who's a partner in Brussels, who's going to talk about the trading and subsidy arrangements. Then Ali Nikpay, who's a competition partner in London, who's going to talk about what's the effect on competition, in particular mergers and acquisitions. And then finally, Michelle Kirschner, who's going to talk about the effect on financial services. They'll each talk for a little bit. I'll then have a discussion with each one of them. And then at the end, we'll have an open discussion. If you've got any questions you want to ask, then put them in the chat box and we'll try and answer them in the course of the discussion. So first, let's go over to Matt, who's going to talk about the basic structure of the deal that was done. Matt.
Thanks, Charlie, and thanks for everyone joining us today in the third in our series of Brexit webinars. In the next few minutes, I'll try to synthesize everything into what you need to know so that we can get on and you can hear from more interesting people on this subject, but I'll try and keep it brief. As everyone knows or should know, the UK formally left the EU on the 31st of January, but since then we've been in a transition period where, as non-members, the UK has enjoyed the benefits of membership while it negotiated the free trade agreement, or rather the larger agreement that was concluded on Christmas Eve. Now, the EU-UK Trade and Cooperation Agreement was agreed, as Charlie said, on Christmas Eve, and Parliament went to work quickly to pass legislation on the 30th of December so as to avoid a no-deal situation. The European Council has adopted it provisionally, so it's pending the consent of the European Parliament, but is still in place and effective until the 28th of February, unless there's an extension by the Joint Partnership Council. Now, importantly, it doesn't require the approval of national parliaments. There's always a risk that that could be the case, but it does require the approval of the European Parliament and the European Council, but it's been assured that that would not be a hurdle. The main hurdle right now on the European side is having the text, all 1,200 some odd pages of it, translated into all 24 official languages. And before proceeding, it's worth pointing out that it's not just one agreement, but there are three agreements as part of this whole package. The other two are regarding the security of classified information and the nuclear cooperation agreement. But for the purposes of this webinar, we're going to focus on the TCA and specifically on the trade provisions there. So the main aspect of the TCA, the Trade and Cooperation Agreement, involve a few parts. The overarching one is the institutional framework which it creates, and that establishes a partnership council consisting of members from both sides who supervise its implementation, provide a discussion forum, And it's where parties can make binding decisions with the consent of the other party. It also creates various committees and working groups to support its work as the agreement is implemented, and discussion takes place over the years on how it changes if need be. Both sides have the right to call for formal review of the entire agreement, and this is automatic after 5 years. So it's important to keep in mind that it's not set in stone. There is always a chance that a future government who, for example, values market access more than it does sovereignty will want to move the levers in different ways. And the framework itself, it does include a mechanism for supplementing the agreement as more details are needed and put into place to make the agreement more functional. Now, the agreement itself, in addition to FTA, the free trade agreement portion, it does deal with law enforcement and judicial cooperation, health security, cybersecurity, and the UK's participation in EU programs such as the Space Agency. But we'll focus on the FTA components today. And the main one there is the tariffs and quotas. As in any free trade agreement, it's not surprising that the headline policy is the fact that there aren't any tariffs or quotas on goods originating in the UK or the EU. And it does set out some substantive rules and procedural rules for the rules of origin on what qualifies for those zero tariffs. And those are rather large because processing activities do count towards the origin and not just the materials that are used. But without the single market and the customs union, there's obviously a lot more red tape than there was before. There's paperwork and document formalities that have to take place that have to be filed every time goods cross the border. So that has expectedly slowed things down from the start. This section also deals with technical barriers to trade, things like sanitary and phytosanitary measures to protect health and plants and animals. But there is provision for a customs and trade facilitation, things like mutual recognition of authorized economic operator schemes and that sort of thing. The services and investment portion of the agreement is probably more notable to a lot of the people in this webinar, mainly because it does deal with financial services and recognition of professional qualifications. On the financial services front, which Michelle will get into in a little bit, importantly, the UK service suppliers don't any longer benefit from passporting, which enabled the automatic access of to the entire EU market on the basis of home state recognition or authorization. But there is an MOU this year that will hopefully establish that sort of a framework. And then capital movements, payments, and transfers is another section that's worth considering. It does enable the free movement of capital subject to various exceptions where those restrictions are needed, for example, in cases of insolvency, responding to economic crises and that sort of thing. Public procurement is a notable aspect, mainly because it does open the market to EU bidders, the UK public procurement market, to EU bidders who do have an establishment in the UK, and vice versa. And it does include provision for small contracts. The level playing field is something that's been bandied about, mainly because it is the bone of contention that existed from the very start of the negotiations. It has resulted in overall stricter conditions that in other EU trade agreements don't exist, but the UK does have the ability to break away from these rules, and the ECJ doesn't have a role for their enforcement, which is a victory for the UK government, so to speak. On the regulation of the environment and labor rights, it maintains the current shared regulations as they are as a baseline, but it allows the parties to change in the future their positions on these areas of regulation, subject to the other side being able to implement unilateral rebalancing measures, for example, implementing tariffs or taxes on various items it feels need to be implemented so as to make things fair again. On subsidies and state aid, there are some basic substantive rules to abide by, and you'll hear from our colleagues on that in a little bit as well. The UK won't copy the EU rules, but it will instead set up an independent state aid authority to create a system with a similar effect to control subsidies. Those subsidies have to be published, and then if the UK changes its rules too much, for example, the enforcement mechanism involves the right to take unilateral remedial measures, as with environment and labor, but then there's also a dispute settlement mechanism of independent arbitration. A few other sections of the agreement deal with digital trade, IP, SMEs, energy. It's quite comprehensive. Fishing is probably one of the more topical subjects that have been discussed, even though it accounts for only 0.02% of the UK economy. It takes up notably more space or more mention in the agreement than does financial regulation. But essentially, the EU fishing rights in the UK waters, for those on the webinar who care to know, the EU fishing rights have been reduced by 25% over the next 5 years. The agreement does have a dispute mechanism, and that involves the in the case where consultation with the other party isn't successful, it involves independent arbitration and excludes any role for the UK or EU courts. And then as regards territorial application, the Channel Islands, they're only included insofar as trade and goods in fishing are concerned. It doesn't include Gibraltar or the British Overseas Territories, but Northern Ireland has an important role to play, being the subject of much of the discussions. It does remain part of the EU single market for goods, but this of course is covered by the Northern Ireland Protocol of the withdrawal agreement. So goods entering Northern Ireland will be considered imports and will have to follow EU rules, including the certification requirements. But there is a 3-month grace period for food on that currently. The protocol will be reviewed by the Northern Ireland Legislative Assembly in 4 years, so it does have the potential to change. And in September, the UK published the Internal Market Bill, which had the potential to upend the negotiations because it would have given, or it would have asserted the authority to amend aspects of the withdrawal agreement and the protocol dealing with Northern Ireland unilaterally. Upend because the EU threatened to not consent to future agreements unless that was rectified. But the main surviving aspect there, once it was amended and survived, is the fact that the UK internal market for Northern Irish goods is ensured. There's ensured an unfettered access of Northern Irish goods to the UK. So in other words, with some exceptions, UK laws won't stand in the way of Northern Irish goods entering Great Britain, and it effectively ensures Northern Ireland has access to both markets. So that's as much of an overview as I could muster in the few minutes that I've been given, but I'll turn it back over to Charlie.
Well, Matt, that was an incredible, in 11 minutes, you've gone through what is a huge agreement, because there was no change in our trading relationships with the European Union upon leaving the European Union. And now there is this massive change from being within a single market and within a customs union to being a trader from the outside, albeit with no requirement to charge tariffs and not being subject to any quotas, but having presumably to prove that the goods that you're sending into the European Union, or the UK if you're from the European Union, in fact come from the UK. How massive a change does this agreement represent in terms of our trading relationship with the European Union? And is it all worked out?
Well, it's definitely not worked out. There are a lot of creases to be ironed, but it is a massive change, even for the smallest of traders. Traders shipping to Northern Ireland, who for all intents and purposes have been domestic traders, are now shipping internationally and have to contend with customs declarations so as their product can enter the EU market technically. Even on the fisheries front, the fact that there has been a reduction in the quota of 25% over the next 5 years, that could have a significant impact. To answer your question very briefly, it's a huge change, and it's a huge impact.
We're seeing problems. And this may be, I don't know whether this is teething or not, but we've got a lot of the fishing fleet in Scotland is moribund and not doing anything at the moment because of paperwork requirements. There appear to be problems of food, retail food, moving from Great Britain to Northern Ireland, and there are delays in relation to goods coming from France to the UK through the Channel ports. Are these permanent problems, or are they simply problems that will be very readily resolved once people get a better understanding of how it all works?
I think it's a little bit of both. Shippers, importers, and exporters will have to get used to the new burden of paperwork on everything coming and going. A lot of it has to do with inspections that are taking place at the border and whether there is enough infrastructure for that to be happening, or whether lorries are going to be queued up at Dover for years to come. So the government, the market, and there's a potential for relaxing the rules and coming up with new ways. Trusted trader programs might be expanded when the government sees how much they're needed, for example. So there's a lot still to be worked out, and the framework that's set up for discussion, whether that be through the Partnership Council or some of the various committees that are there, those will ideally be the table on which those decisions are made.
Okay, that's really helpful. Let's move on to trade now, and Attila Borsos is going to talk to us about the trade impacts. Attila.
Thanks very much, Charlie. Indeed, as Matt mentioned, this is one of the most comprehensive, if not the most comprehensive, trade agreements that the EU has ever concluded with any third country. It was mentioned several times in the post-Brexit era that the UK was aiming at some sort of, for example, Canada-style free trade agreement, and the EU several times stated that that is not something that would be available for the UK because you can't have the benefits of a membership without being a member. That said, this agreement that now the EU and the UK concluded goes well beyond what actually Canada got from the EU. It provides for a free trade agreement, which means zero tariffs on goods traded between the UK and the EU. However, as you can see on the slides, there are two catches there. One is that this agreement is, of course, not a customs union, which means that, as Matt mentioned, there will be formalities. There are formalities that have to be complied with on the border. There are customs declarations that have to be filled out and customs checks that have to be effected. There are also administrative fees that the customs authorities can charge on exporters and importers. These will be longer term, or at least already perhaps mid-term, will be mitigated by cooperation between the customs authorities of the member states and the UK customs authorities. The agreement mentions future cooperation in terms of a single customs declaration, for example, or other ways to mitigate the administrative burden that the customs border between the UK and the EU represents. The second and perhaps even more important catch is that this is not a customs union, which means that the zero tariff only applies to rules to goods originating in the EU or in the UK. Now, the rules of origin are very complex. The rules of origin in this agreement are, of course, based on the WTO principles regarding rules of origin. But I would expect that a lot of companies will need to spend quite some time figuring out whether their goods qualify as goods produced in the UK or third country goods. The rules are very complex. To mention one example, cars were mentioned several times during the last couple of years as, there's this 10% tariff on cars, and if there's a no-deal Brexit, then cars manufactured in the UK would be subject to this 10% duty on the EU border. But also, of course, German cars would need to pay this 10% duty when exported to the UK. Now, of course, in light of this agreement, the tariff on cars is 0%, but that is only on cars originating in the UK or in the EU. And with respect to cars, the agreement determines that a car is qualified as originating in the UK if at least 45% of its value, or the value of its components, were originating in the UK. So there are quite complex rules to follow for companies which then have to make declarations to the exporter, and exporter will have to rely on those declarations. And of course, ultimately, customs authorities will check them. So I would expect that it will take at least a couple of months, if not several months or perhaps a year, for companies to check the origin and the composition of the products that they produce, and perhaps take decisions regarding their supply chain in order, for example, for a car manufacturer to reach the 45% in order to benefit from the 0% tariff on the EU border. The second element of what this agreement doesn't mean is it is, of course, the UK is, of course, no longer part of the internal market. One of the most important consequences of that is that, of course, the parties now have the freedom to set their own standards, their own product specifications, and they can, of course, impose conformity requirements, conformity checks on each other's products. These, again, mid-term, longer term, will be mitigated by cooperation between the UK and the EU. And also, I would not expect that standards all of a sudden will diverge to a large extent, because the parties stated that they will try to continue to align their own standards to international standards. That said, of course, having the same set of standards and having a great convergence between the UK and the EU today, this was perhaps one of the biggest reasons why the EU was keen to make sure that there is a level playing field maintained between the UK and the EU post Brexit. And perhaps we can go to the next slide. It is one thing to provide 0% tariffs or a free trade deal to Australia or New Zealand. It is quite a different thing to provide it to the UK, simply because every single product that is currently being produced in the UK is, of course, entirely conform to EU standards, because until about a year ago, the UK was a member state, and actually the UK was one of the most compliant member states. Unlike France or Belgium, or sometimes even Germany, the UK has the best score in terms of implementing secondary EU legislation on product standards, for example. So the EU, there was a concern in the EU, and this is why they pushed for level playing field provisions, that the UK, in a free trade agreement, because its goods are conform with EU rules, could somehow outcompete EU companies and obtain an undue advantage for its companies. And this is why within the free trade provisions of the agreement, there are level playing field provisions on competition policy, subsidy control, taxation, state-owned enterprises, environment and climate, and labor and social standards. Now, most of these areas don't really go beyond the agreement. In most of these areas, doesn't really go beyond expressing best endeavors, future cooperation, sort of clauses where the parties express the wish to cooperate and not to undermine, for example, labor or environmental standards. But the one area where the agreement is quite specific, that is subsidy control, which is actually the good old EU state aid control. Now, as Matt mentioned, the UK will not entirely copy the EU state aid control regime. That said, if one looks at the agreement, and if one was looking for a good summary of the thousands of pages of EU state aid control legislation and guidance and notices, the agreement gives quite a good 12-page summary of what is EU state aid control. Now, very importantly, state aid control or subsidy control will be not only relevant if there is a distortion of trade between the UK and the EU, but also if one of the parties consider that investment is also distorted by the subsidies that either the UK government or one of the EU member states governments granted to their companies. Each party will be responsible for its own state aid enforcement. The agreement provides for effective state aid enforcement and setting up of an authority, which I believe the UK will do over the course of the next couple of months. And also, in a way, it creates a new forum for competitors to complain about state aid. Now, state aid control, on the one hand, the UK government was, for some reason, always seemed to be keen to implement and have an effective state aid control in the UK, but this was really something that the European Commission pushed for in this agreement. And interestingly, this is actually something that, if depending on how the UK government would want to use it, these provisions are also something that UK companies could use if they think that the European Commission didn't implement state aid control effectively. So, for example, the state aid control regime and subsidy control regime is not only extended to the trading goods and the potential effects on investment, but also to the aviation sector. So, for example, if British Airways in the future complains to the European Commission about the state aid that one of its European competitors received from for example, the German government or the French government, and BA is unhappy with the way that the Commission deals with the question, it could ultimately complain to the UK government, and then the UK government, if they wish to do so, they could pick up this question with the European Commission and take it to dispute settlement between the UK and the EU. So it remains to be seen how effective the regimes will be and how often the UK will complain to the Commission about the enforcement of the Commission by the Commission, and how often European companies and the Commission itself will complain to the UK authorities about how the UK implements state aid rules. So that remains to be seen, but this is something that is potentially interesting also because, again, it creates an additional layer and a potential control mechanism to control what the European Commission does. And I think with that, I would turn it over to the competition policy questions, unless Charlie has questions.
Yeah, no, that was very interesting. I mean, Attila, the sort of three bits I'd be quite keen on. First of all, you've identified that there's quite complex rules of origin rules that now apply, in particular working out whether or not 45% of the processing, for example, of a car comes in the UK. Is this going to have a very bad effect on our trade with the European Union? Why would you bother getting into those issues if you're buying cars, if you can buy it much more easily from a manufacturer in another part of the European Union?
Well, I think it has to do with the fact that there are car brands that have UK factories that produce for the entire EU market. So obviously, it's very difficult to relocate manufacturing facilities. It won't happen overnight. That's one thing. And the second thing is, these rules are very complex, but both UK and EU companies already have to work with these rules had to work with these rules when they exported outside of the EU. So if a German manufacturer was exporting cars outside of the EU, they already had to declare the origin of that car. Of course, what was somewhat easier when the EU still had 28 member states, that I would guess that, just to state the example of the cars, it is easier to procure all or most of the components for a car if you have to procure it from 28 member states. And it doesn't matter whether a certain part comes from Slovakia or France or Germany or the UK. Perhaps it would be more difficult for UK companies to make sure that 45% of the components of the car or the value of the car comes from the UK or the EU. Because, very importantly, the treaty or the deal also contains an accumulation clause, which means that when you determine whether a car originates in the UK, the components originating in the EU count as UK components. So the UK companies are not penalized for using components from the EU, and also, of course, the other way around.
But I mean, it is the general problem of uncertainty going to make UK cars less attractive? Because if you don't establish the 45%, you don't get the benefit of quota-free and tariff-free access to the European market.
I think it could make potentially longer term less attractive to maintain or create new production facilities. But for the ones that are there, it's an additional administrative burden. Again, something that companies have already done for export outside of the EU, also within Europe, outside of the EU borders. So I don't think that in itself, of course, if a car doesn't fulfill the criteria of 45%, then it will be subject to a 10% duty on the EU border.
On the level playing field provisions, not the subsidy control, but the level playing field provisions, apart from that, have we ended up with absolutely normal ones for a trade agreement like this?
With the exception, perhaps, typically the latest generation of EU trade deals would include provisions on labor and social standards, also on environment and climate. Taxation is a bit trickier. This is not something that we can often see, and not to this extent, although again, it doesn't go beyond declaration of principles and future cooperation, but tax clauses are not typically part of trade agreements with third countries.
Okay, and then on subsidy control, is that not more of an advantage to the UK than the EU? Because we traditionally as a country are much less generous in subsidy control state aids than the European Union countries are. And this gives us an opportunity to try to, as it were, restrict the ability of the European Union to unfairly support its own local industries.
I fully agree with that. Again, I think this was something that the EU pushed very hard for, so that the UK can't all of a sudden grant subsidies, and then UK companies whose products are conform with EU standards can export at 0% tariffs to the EU while benefiting from the subsidies. But I agree with you. Again, I think the Commission is used to being sort of the last voice, of course, except for the General Court in the Luxembourg, in EU state aid control. And I'm sure they thought it through, but it will be interesting to see how UK companies who are unhappy with their European competitors receiving state aid in Europe, the Commission not doing anything about it, or not fast enough, or not, the Commission doesn't go far enough in controlling a certain subsidy. This treaty, this deal creates a new possibility for those companies to have a second forum to complain about those subsidies that other European states grant.
Okay, so that was so interesting. Can we move on to Ali Nikpay now, who's going to talk about the competition aspects of the level playing field? Ali.
Sorry, I was on mute. Charlie, just on that last point, I mean, I think you'll know more about this than any of us. But I mean, the UK government has, and I believe also the Labour Party, have expressed an interest in making greater use of the state aid power outside of Brexit. So I think this is an area where UK policy is likely to diverge from what we've seen in the last 20 to 30 years. And so my guess is this area will actually be quite active, and people, if companies have concerns, there are opportunities to deal with them either through either of the mechanisms that Attila talked about.
I think that's right, and I also think that in the context of particularly the UK government, but also the opposition, thinking much more about an industrial strategy. If you want to have an industrial strategy, which, for example, is promoting particular sorts of commercial enterprise, in particular digital, artificial intelligence, but not just that, also manufacturing, you don't want to be too restricted by state aids rules from the European Union, and equally, the European Union wants us to be as restricted as possible in relation to that. And as Attila is saying, the effect of this agreement is in clause 3 of the level playing field stuff is to, as it were, lay out in one provision agreed principles of state aid. Are they not? Have they not? So there's a common definition.
There is, but there's I mean, Attila can maybe come in on this, but there is an awful lot of, the devil is in the detail. So we've got general principles, but the UK can create its own rules within those general principles, and there's quite a lot of flexibility. My reading, at least, till she come in, my reading is quite a lot of flexibility, and my guess is there's going to be this is going to be an area of potentially some tension between the UK and the EU, in the way that it has been with the US, actually.
Sure, the tension may also come from the fact that state aid control doesn't cover financial resources provided by supranational entities, which of course means in this context that if there is an EU fund that provides aid or financial resources to a certain industry in order to implement EU industrial policy, that is not covered by EU state aid control and the EU state aid control provisions. So you may end up in a situation where the UK government, which is of course at the national level, is under an obligation according to this treaty to control subsidies, even if it wants to, of course, with a lot of flexibility when it wants to implement an industrial policy. And at the same time, yes, the German government, the French government cannot grant state aid without being controlled by the Commission, but the Commission could grant significant financial resources to companies from European funds, because those funds do not fall under the scope of this deal and under subsidy control.
I think on the thing that is really interesting, I mean, obviously the principles, but also the effect of the deal is to require the UK government to set up a domestic enforcement of those principles. So what you're going to see over the next years is the creation of this body, and it might be the CMA or some body that already exists that does it, but it's going to be in commercial parties' interests to try and attack support that the government gives to its rivals, allegedly breaking the principles that are set out in the deal. And that is going to become, I suspect, a new form of hostile commercial activity, not, as it were, to foreign companies, but to your own domestic rivals, if it is being said you get support from the government. So I think it's going to spawn quite a new area of legal activity. But Ali, back to you on competition.
Sure. So I think there are two or three other areas. We've talked about the most high profile one, state aid, and the one that caused I think very significant friction during the negotiations. But in terms of where we stand on competition, I think very briefly I'm going to cover mergers, the effect on mergers and deal making, and then antitrust, cartels, and then very briefly private litigation. So on the deal side, this is the end for in some ways, this is the end for the one-stop shop. So a deal that met the European Union's jurisdictional thresholds, there's only one filing for the whole of the EU. Post 31st of December, that falls away. And so what that means is that deals potentially can fall both within the UK jurisdiction and also within the European merger controls. So you're looking very likely at increased administrative burden, and not just actually through the UK, the additional UK filing, but potentially also more filings at the member state level, because once you take out the UK turnover from a company, the consequence of that may well be that certain deals don't fall, deals that pre-Brexit would have fallen exclusively to the European Union to deal with. As a result of withdrawing the loss of the UK turnover, consequence of that could be that they don't meet the European thresholds, and therefore there may end up being filings required in individual member states. So this is, in terms of administrative burden, that's a potentially a significant one, and not just for UK, from a UK perspective. The second point is uncertainty, risk that the EC and the CMA may reach different outcomes. That's of course already there, because the US could reach a different view, Australians and so on. But of course, the UK economy and the European one is closely aligned. So the risks are more pronounced potentially here, and in that sense, we know and we can see over the last 18 months, 2 years, that the CMA is taking an increasingly tough stance. In the last couple of years, they've blocked 7 deals and caused at least 10 others to be abandoned. I mean, that's a record number for almost any authority of any significance, and they've significantly increased the proportion of deals that go to phase 2. So that's something really to watch out for. But more interestingly, actually, I think, is the fact that the European rules, the one-stop shop, placed a limit on the ability of member states to intervene on public interest grounds. The tests are fundamentally competition and competition, but there was some minor or rather narrow scope under the EU rules. Of course, this now falls away. The UK government is no longer bound by the European rules on merger control, and is in the process of introducing a radical new foreign direct investment regime. It's rather misleadingly called the National Security and Investment Bill. It's not about national security only. The implications of the bill go far, far wider than national security. People shouldn't be lulled into a sense of thinking it's just about defense. It really isn't. And it requires mandatory notification in certain broadly defined areas of the economy, backed up by a call-in power, and as well as voluntary notification, applying to really a very wide range of transactions that nobody would think could possibly fall within any sort of even vague concept of national security. We're currently dealing with 3 or 4, where at first glance, I mean, the clients have turned to us and said, well, how on earth can this potential thing be national security? Answer is the bill is drawn very, very widely. To some extent, it's whatever the government or the Secretary of State for Trade and Industry thinks it is at any point in time. So I think we really have to watch for how that develops, because that is potentially a very significant change to UK merger control. Turning to antitrust, similarly, sort of the one-stop shop ends there, because as people may know, once the European Commission had opened an investigation, member states are not permitted from taking antitrust action. That sort of ends their powers. That falls away for the UK. However, I think the impact, unlike in mergers, where the CMA has already announced it's going to be active in parallel with the European Commission, on antitrust it falls away because there's no duty on the CMA to investigate any antitrust cases in the way that there is a duty on merger cases. So it really depends on their resources and their priorities. I'm not expecting very significant change. I think they will leave many of the cases to the European Commission to take forward, with one exception, and that's in the area of digital. There, the CMA really is one of the lead agencies, and they are perhaps one of the more aggressive authorities when it comes to the digital new economy. So for those involved in that area, something to really keep an eye on. And then finally, very briefly, private litigation. Pre-Brexit, EC decisions had binding effect for the purpose of private damages actions. In other words, they could form the basis of a follow-on claim. You didn't need to reprove your case, reprove that competition had been damaged. What you then had to show was the causation and quantum. That was the situation pre-Brexit. Post-Brexit, that largely falls away, or rather will over time fall away. This binding effect continues to apply to decisions taken by the European Commission before the 31st of December, and also on any cases that were initiated before 31st December. But beyond that, that falls away, and cases will have to be reproved in the courts in the UK to the extent they're brought here. It sounds like a major change. In practice, I think it isn't likely to be that significant. I'd be interested in your views, Charlie, as an eminent QC, but I think the UK courts are likely to give quite a lot of weight to EC infringement decisions and have quite significant regard for them in terms of the evidentiary burden of proof for establishing an infringement. So although it won't be binding, I suspect the UK courts will pay a lot of attention to them. Therefore, practically, the effect will be relatively muted. I'll perhaps stop there.
Ali, thank you. I completely agree with you that the change in relation to follow-on actions, that the Commission decisions are not binding, but English courts are going to not want us to be going in a different direction, particularly because there's no reason to treat these decisions as on a false basis. The thing that was very interesting about what you were saying was the combination of the wrongly described National Security Act and leaving the European Union is going to have a big effect on merger control and the intervention of the UK government into merger control, particularly presumably where it's non-UK money that is seeking to get involved. Can you give us some indication of what you think the effect is going to be in practice? You've identified the cases that we're now involved in. What will it involve when somebody is seeking, for example, from outside the UK to take over or merge with a UK company?
I think they have to assume. Well, it's really interesting, Charlie, because actually the UK, until probably about 2 years ago, the UK had arguably the lightest touch merger control regime, antitrust and sort of national security of any of the major economies in the world. We have, and I think arguably now we've gone from having the lightest touch to potentially the heaviest touch. I think the government is going to be overwhelmed. The BEIS, the Department for Business, I think is going to be overwhelmed with the number of notifications. on the under the national security, because the way the bill is drafted, it is very, very wide. First of all, it's very, very wide. So it is almost anything that almost whatever the senior civil servants and ministers think is a national security problem becomes one. So you have to have attention to that. So I'm expecting people to put in filings just to be on the safe side. Now, why would you do that? Well, because for two reasons. One, and I'm not sure this is legal, but anyway, it's in the act, in the bill. The bill is retrospective, right? So if right now, you're aware of the bill, the government can come after you, even though the bill hasn't been adopted by Parliament. And the government's given itself quite a long time, a number of years, in which it can investigate. So years can go by. You get clearance from every other jurisdiction in the world. You're getting on with your deal. You've completed. You've done everything, and then the UK government could pop up, after 3 or 4 or 5 years, and say, "Well, hang on a second. I think there's a national security issue here," and could seek to take remedies. And that, I think, is going to encourage people to put these filings in to prevent that from happening. So I'm expecting a lot of deals to be notified, bays to be overwhelmed, and to struggle with dealing with them. And then I think we have to see how this plays out. I don't think they've thought it through particularly well.
Hardly surprising. Now, last speaker is Michelle Kirschner. Thank you very much indeed for that, Ali. That indicates that life is going to change. The Christmas Eve deal in financial services. Michelle.
Thank you, Charlie. As Matt's already said, the UK-EU Trade and Cooperation Agreement does very little, doesn't really talk about financial services all that much, and it does very little to facilitate access to the EU single market by UK financial services businesses, and vice versa, for EU firms looking to access the UK markets from the 1st of January. From the EU's perspective, a natural consequence of the UK's decision to leave the EU was the losing of the ability to rely on passports, which so many of the UK businesses have used to access the UK markets over many, many years. And of course, vice versa, be that on the basis of the right to establishment or freedom to provide services on a cross-border basis. This loss of the passport is really quite important, and particularly for UK businesses, because financial services has been such an export success story for the UK, with around 40% of UK exports of financial services going off to the EU. And until very recently, much of that export business had heavily relied upon passports. And it is very clear that those have gone. The EU's position throughout the negotiations was passporting is the sole preserve of members of the European club, and it is no longer something which UK firms can rely upon. And also it's something that EU firms can no longer rely upon in order to access the UK markets. So the agreement doesn't say much about financial services, but I think it's worth just spending a minute or two just in terms of what it actually does say. In relation to market access, the agreement provides for some general rules for cross-border financial services between the two parties, such as no limits on the number of financial services providers, no limits on number of transactions, etc. However, what it really doesn't do is allow for broad market access under concepts such as equivalency, which we've heard such a lot about, or mutual alignment. Fundamentally, the agreement doesn't really go any further than the EU-Canada Comprehensive Economic Trade Agreement. The agreement doesn't provide for most favoured nation clause in the area of financial services, so neither party can claim more favourable treatment granted by either the UK or the EU, respectively, in their future agreements on financial services with other third countries. So really, while the agreement does provide for more liberal market access between the UK and the EU than would have been applied under the WTO and GATS rules had there have been a no-deal scenario, the agreement absolutely falls well short of liberalising financial services in any way close to the EU's single market. And one of the main reasons for that is the so-called prudential carve-out, which essentially enables either party to adopt measures for fairly broad prudential reasons, including investor protection, depositor protection, or market integrity. In the area of international standards, quite understandably, the agreement sets out that both parties are committed to incorporating internationally agreed standards into their financial services regulatory frameworks. That will include, for example, standards adopted by the G20, by the Financial Stability Board, by IOSCO and the Basel Committee on Banking Supervision. So in light of all this, let's have a look at the practicalities for actually accessing the EU market going forward. So if we can have the next slide, please. The options for firms in third countries to access the European market, and this goes for the UK and indeed other third countries, are essentially fourfold. Passporting, which, as I've already discussed, is an exclusive benefit of membership of the EU. Trading with the EU on the basis of WTO and GATS terms, which would have been the case in the case of a no-deal scenario. Equivalence assessments and decisions, which we'll come on to have a look at in a little bit more detail in a moment or two. Or indeed a free trade agreement, which is obviously where we are for the most part for now. It doesn't provide comprehensive market access for financial services between the two parties. Such coverage would have been pretty unique in the context of free trade agreements. So what is equivalence? We've heard such a lot about it over the last 4 years, and such a lot of store has been put into equivalence by so many people. But importantly, equivalence is not and would not ever be a replacement for passporting. It doesn't provide for unfettered access to the financial services spectrum. And essentially, there is no single equivalence regime. There are a number, quite a lot of equivalence regimes set within financial services legislation within the EU. And it's not comprehensive. It doesn't include everything. So, for example, many core banking services such as lending, payments and deposit taking cannot be provided to the EU under any equivalence regime. On to the next slide, please. Within the European legal system, there are essentially two primary purposes of equivalence. The first one being to grant EU firms preferential prudential treatment to certain categories of exposures to entities outside of the Union in the same way as they apply to exposures to EEA entities. The other purpose of equivalence is to enable market access for firms from third countries to provide certain services within the EEA without requiring full authorization within the EEA, within an EEA state. Despite the often common misconception that equivalence is all about market access, equivalence granting market access is actually pretty limited. In relation to MiFID activities, for instance, the equivalence regime isn't operational at all. It's never been used. Consequently, no jurisdiction from under the third country regime has been deemed to be equivalent. On the other hand, a number of third countries have been deemed equivalent under the European Market Infrastructure Regulation to enable their central counterparties and trade repositories to provide derivatives clearing and other services to EEA counterparties. Essentially, equivalency is being used where it's in the interests of the EU to grant that equivalency. So on to the next slide, please. Equivalency isn't the panacea in my view. We saw starkly with equivalence assessments and decisions relating to the Swiss trading venues under MiFID II and MiFIR, where there are broader political considerations at play, that those equivalency decisions can be withdrawn at relatively short notice. It also serves to demonstrate that equivalence is not necessarily a permanent position. It can be withdrawn in sole discretion of the European Commission. Equivalency is therefore something that a third country can request. It's not negotiated, and that is fundamentally why equivalence isn't found within the free trade agreement. It's a technical regulatory process where the outcome really isn't certain, especially, as I say, where political considerations are at play. I think a big question for the EU when considering equivalence in relation to the UK will obviously be the extent to which the UK will diverge from EU regulatory standards over time. So that's going to come into play in relation to that initial decision, and it will also come into play when the EU monitors and reviews those decisions over time. An example of where the UK is already diverging is in relation to the area of ESG, where the UK has announced that it will not be onshoring the Sustainable Finance Disclosure Regulation. Of course, the extent to which that actually represents real divergence will only really be seen over time. But it is something that the EU will pause to consider when they're looking at equivalency for the UK. My personal view is that there is a big difference between granting equivalence where it's in the interest of the party granting that equivalence in order to make financial markets work efficiently, as opposed to where you're looking at granting equivalency to allow firms from another jurisdiction to come in and provide, for example, investment services, where those services could be provided just as easily by investment firms within the jurisdiction of the party being asked to make the equivalency decision. But what for EAA firms looking to access the UK market? Obviously, of course, the traffic isn't one way here, it is two way. The position for European firms looking to access the UK is to an extent different. The UK has granted a wider package of equivalency to the EU, which was announced back in November 2020. The EU made a similarly has made some equivalency decisions, but they are much more limited, both in terms of scope and also being time limited, and are limited to derivatives clearing and settling for Irish securities. The UK has, of course, implemented the temporary permissions regime, which isn't replicated at European level, which essentially is there to support EEA firms who have been operating in the UK on the basis of passports for a period of time before they need to seek separate authorization within the UK. There are some domestic regimes across the EU, with Ireland, for example, and Denmark having implemented some limited domestic transitional regimes. So what are we going to see next? Alongside the trade agreement, the UK and the EU made a non-binding joint declaration on cooperation, and that's really going to be the sort of the next big thing, so to speak. And that is really where the parties are going to agree how their relationship of cooperation will work going forward, with the view to a memorandum of understanding being agreed between them by the end of March. My personal view is, if we can all play nicely in the sandpit in negotiating and agree in that MOU, I think that will set the scene for the future relationship, and in particular for those equivalency decisions that will be so important going forward. If we don't all play nicely in the sandpit, I think the converse will happen. I think we are almost at the top of the hour, so I'm going to stop there.
That's really helpful, Michelle. Thank you. We are at the top of the hour, and we don't dare trespass upon beyond the hour. Michelle, thank you very much for all of that. It was incredibly interesting. There's so much to learn in relation to all of this, and we're here to help you in problems that people on the webinar will have in relation to navigating their way through the agreement. There will be a lot to learn, and there'll be a lot more to agree between the European Union and the UK, and I think it really much depends upon whether the political will is there to be close, or whether the political will is there to take competitive advantage, and that remains to be seen. To everybody who's joined in, thank you very, very much indeed, and we'll be back with more in a few weeks on more detail on the agreement. Thank you very much indeed, everybody. Good afternoon.